Hello and welcome back to the Data Privacy Lawyer. It's Funmi, Principal Attorney speaking. So today's privacy review is going to be on Dr. Pepper. We're going to be taking a look at the privacy notice today. Now, I refer to it as a privacy notice. We can see here that it is also referred to as a privacy policy. I didn't know this, but it looks like Keurig and Dr. Pepper have merged, which is interesting. And that's not insight that I knew about. That being said, I want to make mention of this because generally, if a merger is going to occur between organizations, there needs to be a reconciliation of the privacy programs that both organizations have to make sure that both, as they merge, are complying with the data protection laws and the representations they've made to consumers, not only in the past, but going forward in the future. Let's take a look at the policy. The first thing I want to take a look at is when this was last updated. So that's very interesting. There is no date that this was last reviewed. Now, some data protection laws actually require a date to be provided, and that's not been done on this particular privacy policy. Let's keep going through. So this particular policy applies to information collected through the company's website, web pages, interactive features, sites, ultimately. So we can see what the scope is of this privacy policy. One thing that I would do, given the fact that there's so many different applicabilities for this policy, is I would take a look or ask the organization to list all the types of information that could be collected through the company websites. Now, the reason I've made this question or inquiry is because some websites collect information related to employees or prospective employees. Now, comment that I want to make about why this is essential is because when we look at employee personal data and prospective employee data, the handling of both sets of personal data belonging to these data subjects not only has to be looked at from the lens of the data protection laws, but also the applicable labor laws in a specific geography. So when you're a privacy lawyer, you look at all of the different data subject groups that a company processes the personal data of. On this channel, we generally look at companies and the data subjects associated with consumption of products and services. But companies like Keurig Dr Pepper, they don't just process personal data related to their customers. They have employees, they have people that are looking to work for their organization, they have vendors. There's lots of different groups of data subjects of whom Keurig and Dr Pepper process those personal data elements. And the treatment of each category of data subject needs to be handled in a specific manner. How you handle customer personal data and your obligations under the data protection laws is going to be different to how you handle prospect employee data, which is why it's important for companies to be very specific about applicability for their privacy policies and notices, because that influences what you need to be saying on your site and the representations that you make to the consumers or readers of your public-facing privacy policy. The site may ask you to provide information that could reasonably be used to contact you or identify you personally. Now, I'm very interested about this definition. I would be intrigued about the geography in which they've utilized to create this definition. And the reason I said so is because Keurig Dr Pepper is a global organization. This definition may not necessarily capture every geography where the goods and services are provided. That's why, again, you have to look at the scope. I don't know for a fact every single identifier collected by the website. It may be that the personal data collected through the sites is only specific to one geography, but every provision that you write on your privacy policy has to align. If you're providing a definition on what constitutes personal information, you need to look at all of the geographies where you're collecting information applicable to the sites. So let's say, for example, and I don't know this for a fact, I'm just giving you an example, the company's website collects information from customers in the United States, but then the blogs and the text numbers and social networking sites associated with this privacy policy collect information from consumers in the European Union. The definition of what constitutes personal information needs to not only take into consideration what US privacy laws consider personal data, but it also needs to take into consideration what the European Union data protection laws constitutes as personal data, and it needs to be clarified because your users and the people reading this privacy policy are going to have certain rights as it relates to their personal information. So I hope that's clear. How we use the information collected through the sites. Any information you submit on the sites will be used for a variety of business purposes, including, for example, to respond to your questions and requests, provide you with access to certain areas and features of the site, etc. Now, I want to call to your attention this section. This language implies that the business purposes for which the information that is submitted to the sites, there could be more business purposes than those provided within this provision. That's what including, for example, means to me. Now, from a transparency perspective, companies need to be transparent about how they use personal data, full stop. When a company chooses to use language like including for, it infers to the consumer that there are additional ways in which their data is being used that is not necessarily placed on the site. Now, what I can say is that under the FTC Act Section 5, businesses in the area of commerce need to ensure that their privacy practices are not unfair or deceptive. Now, what that translates to from a privacy perspective is you need to make sure that your consumers know every single way that you constitute to be a variety of business purposes. So generally, businesses should list every single business purpose. Every single business purpose would mean that you're not being deceptive to your consumers about how you use the information they submit on your sites. Choice and access. Now, we haven't talked about this in a while on this channel. I want to talk about rights. So the choice that a consumer has is based on where the data subject or individual resides. The obligations that Keurig and Dr Pepper have are determinant on where a consumer of their products and services or a consumer of the sites, which is the scope they gave above, is geographically located. So I'll give you an example. If a California resident is purchasing a good or service from Keurig Dr Pepper, their choices or rights are influenced by the California Consumer Privacy Act. If Keurig or Dr Pepper is providing those same goods and services to an EU resident, then the GDPR, which is the data protection regulation in the European Union, is going to apply. Keurig Dr Pepper has the obligation to fulfill obligations under the CCPA and the GDPR because they process the personal data of residents in those geographies. And that's just an example. Security of your information. Now, you might be wondering, why is it that a privacy policy is talking about security? The reason is because security and privacy walk hand in hand. Many data protection laws have obligations on organizations to have technical and organizational measures as it pertains to the safeguarding of personal data. So not only do companies have privacy obligations, they have security obligations under many of the data protection laws. Again, it depends the geography in which they process personal data. So I really hope you enjoyed this particular review. If you have any questions or comments about my deep dive into Keurig Dr Pepper's privacy policy, leave a comment below and I will see you in another video.